part two of our story is leaving the international and even regional human rights level and coming down to the constitutional level. And what happens, I had mentioned at the very beginning of class that before World War II, there were about 5 constitutions that just mentioned dignity. Now there's more than 170. There are about 194 nations in the United Nations, and more than 170 of those have constitutions that talk about human dignity. In addition to that, there are other constitutional systems where the Constitution isn't explicit about dignity, but the courts have interpreted it. Canada is an example of that. Actually, most of the Commonwealth, the former Commonwealth constitutions are that. The US, Canada, New Zealand, Australia have limited bills of rights and no mention of dignity. And the UK, of course, and their courts have read dignity into the constitutions. So that's what we're going to be talking about in this hour, is what happens when this idea of human dignity that comes to us from the UDHR sort of diffuses down into the national domestic law of countries. I'll just say at the outset something that I just want to be clear about. I think that it's very important sort of in looking at the history to understand that founding moment in 1945, 1948, to understand why we're even talking about dignity in law today. That's really important. But I think the turn from international to domestic constitutional law is incredibly important also. And it's important for a couple of reasons. Let me just ask, by the way, how many of you were at the conference in the last couple of days? Okay. All right, good. Yay. Wasn't it great? Because I mentioned this at the conference, I was just wondering. I think it's really important for a couple of reasons. I'll mention 2 in particular. One is that international law and regional human rights law, even when it's binding on the nations, is really, 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 really hard to enforce, right? It's very hard to get an opinion from the Human Rights Committee, or even from the Inter-American or the European Court or whatever. It's just if you think about the numbers of people and the numbers of judgments, it's really, really hard to do. And the amount of resources that go into any one of those judgments makes it very difficult for most people who feel that their rights have been violated to go to the international or regional level and get their rights vindicated. Same is true of constitutional courts, but not as much, right? It's still hard to get before a high court in some countries more than others. But even in those countries where there's relatively open jurisdiction and open standing, as you might have here, and the court decides a lot of cases every year, even in those situations, it's still hard to get there. Most people who feel that their rights are violated can't get a judgment from a court, but it's better. So that's a really important point, is just that it makes, if dignity is going to be important in law, if it just stayed at the international level, we would really, it just wouldn't affect people, right? It'd be nice on paper, but it really wouldn't affect people. The second reason is that courts do this one amazing thing. They do 2 good things, but one of them is really amazing. They decide cases, so that's nice. But they decide cases with opinions, and that's great. Well, first of all, it gives law students something to read, right? But more than that, it explains what the law is. In fact, I think the very last panel of the conference, there was a paper about dignity meaning the right to a justification for government action. The right that because we have dignity, we have a right to have the government explain its actions. And one of the primary ways that governments do that is in written judicial opinions. And for our purposes, what these written judicial opinions do is they explain what dignity means. And I mentioned this at the very beginning when we talked about the course goals and understanding the vocabulary and the meaning. We get that largely from the cases because, frankly, as we saw from the UDHR, there's not that much there. You don't learn that much about what dignity means from just reading the UDHR or even the other international treaties. So we get explanations, we get vocabulary, we get this sort of putting this elaboration. So we're not just focusing on one word, we're getting a sense of the meaning. So that's important. The third reason I think that it's a very important sort of turn towards constitutionalism is that one could make the claim, and many people have made the claim, that documents like the UDHR, like the UN, whatever, that there's a certain Western, imperialism, Western values imposed on the rest of the world, all of that, without going into either the details of that argument or what we think about it. I think that taking an idea like dignity, which is sort of as your question point, sort of highlighted, everybody sort of agreed that it was important and was willing to sign on to the document and has signed on to all the other international and regional human rights instruments about dignity, but without sort of much elaboration of what it means. Constitutional courts obviously operate within a single nation. And that gives each country the option, first of all, to decide, do they want to have dignity in their constitutional system or not? Right? You can sign on at the international level and then say, yeah, but when it comes down to what our law is going to look like, this isn't a concept that's relevant to us. Or if you say it is a concept that's relevant to us, you get to shape it and define it and make it your own, right? So it's not a matter of values imposed from outside. It's a matter of, it becomes homegrown, if you will. And so I think that's also really important in understanding and sort of accepting the place of dignity in law, because now we see it not just as this international, sort of internationally imposed idea, but something that is coming sort of from the ground up in any given country. Okay, so I figured I may as well start here. And I just want to, and I'm not going to go in detail. This is the only slide I have on the Indian Constitution. So obviously there's much more in the Indian Constitution about dignity. And we had a really fantastic presentation at the conference about the places where dignity is explicit and the places where it's implied, and of course, most famously in Article 21 in the right to life, but also in other parts of the Constitution that don't use the word dignity, but are all about dignity in very much the same way that we're thinking about it here. So I just wanted to sort of have one slide that just mentions the place of dignity in the preamble. You can see, and I mean, for me as an outsider and somebody who's not an expert in Indian constitutionalism, but who studies this, it's so interesting to me to see this very, very early post-war constitution already adopting the notion of dignity, but not in a sort of foregrounded way. At the same year, in 1949, the same year that this is drafted and adopted, the German basic law is also, and Germany takes a very different approach to dignity. Like the Indian Constitution, it mentions it explicitly, but it mentions it in a much more emphatic way. Article 1 of the German Basic Law says dignity shall be inviolable. And just, we're starting that, and that, has to do with Germany's own post-war history, right? And so there's different ways that it shows up in constitutions. We'll look at some of these texts, but I just wanted you to all be clear about that. So we also, and on the Dignity Now website, there's also a link to a database that a former colleague of mine has been maintaining with dignity provisions in constitutions. So there's about 160, 170 constitutions that mention this. This is just some examples of how it shows up in different constitutions. So sometimes it's associated with very specific things. The economic order, founded on the appreciation of the value of human work and free enterprise, is intended to ensure everyone a life with dignity. That's from Brazil. Belgium, everyone has a right to lead a life in keeping with human dignity. In Pakistan, it's in a provision about the right to privacy and the right of family life. Dignity is there. Colombia, the right to dignity is guaranteed, but we leave it to the legislature to provide the manner in which it shall be upheld. Kenya's is interesting. The purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals and communities and to promote social justice and the realization of the potential of all human beings. So we see some of that language there, but just notice how in Kenya, it's not so much that it's a right, but it's the purpose of all other rights. So we've talked about dignity as the foundation of rights, the source of rights. Dignity is the right to claim your rights. Here we see it slightly differently. The very purpose of human rights is to protect dignity. And we see that also in my favorite one. You have to have a favorite constitutional provision if you're like a constitutional law nerd. But Peru, the defense of the human person and respect for his dignity are the supreme purpose of society and the state. I just think that's a remarkable sentence, right? The reason we come together and organize as a state, and the reason we have society with societal norms, the reason for that is to promote human dignity, to defend human dignity. Here's Article 1 of the German Basic Law from 1949 that I mentioned. One of the most famous ones is South Africa's constitution, the post-apartheid constitution, that mentions dignity as a foundational value of the new South Africa, but also as a right. In Article 10, everyone has inherent dignity and the right to have their dignity respected and protected. So again, you're recognizing the language, right? Inherent dignity connected with rights.
Is there any place in the world where this aspect is enforceable in law, where I can approach a court and say my right to a dignity has been violated, and please enforce it in so and so manner?
Yeah, so at a certain level, broadly speaking, yes, in lots of countries, and the database that I had mentioned before about the cases has hundreds of cases of examples of that. Most of those are cases that are not as precise as what you're asking, right? So most of those are cases where somebody claims an equality violation. And the court says, in order to protect your dignity, or it's associated with, we're invalidating this because it violates equality. It's often connected with other things. There are a few cases, and again, I mean, there are so many dignity cases, I don't know them all. But I know of a few cases where it seems to me that the court is invalidating something, and really the only thing is a dignity violation. So there are situations like that, but it is broadly enforceable in, I believe, in every country that has an active constitutional court. So there are countries where there isn't a constitutional court, right? Or the constitutional court isn't doing any work, right? But in any country that has constitutional jurisprudence, I have not found any country that has constitutional jurisprudence that doesn't recognize dignity as a constitutional value or right. Even, frankly, even in the US, where its rights are much more limited. Sure. Well, can we just have one question? Yeah.
So you talked about how each country can make dignity their own, and they have done that. And within that context and the context of cultural relativism, how do we decide then what the concept of dignity is? Because in my understanding, it's a lot more fluid, and that's where each constitution has its own understanding of it. But since it's inherent to the individual, each individual will also have an understanding of their own dignity. And that dignity might not always be in coherence with the dignity that the constitution that individual exists under is understanding dignity to be. So can we then say that dignity is only what the constitutional code makes of it?
So, I mean, that's, sort of the big question, right? About how courts are interpreting it and how we understand this very broad and very diverse body of law. So I will tell you, I'll put my cards out on the table and tell you how I make sense of it. And you can tell me by the end of the week whether you agree or have a different way of making sense of it. I'll talk a little bit about, I'm going to talk in the next hour about the cases and what the courts are doing in these cases. But since you asked the question, what's fascinating to me about this area of law is that the cases are geographically global, right? All over the place. They touch on an incredible range of rights or dignity issues, right? So we didn't go through all the rights in the Civil and Political Rights Convention or the other convention, but those list, dozens of rights, and constitutions list other dozens of rights, right? And dignity cases can come up in any one of those areas. A dignity case can come up in any one of those areas. And I'll talk more about this. But what's fascinating to me about it is that despite that incredible diversity and the cultural specificity of each constitutional court's jurisprudence, there is what I've called, it's not my term, but I've appropriated it for this, an incredible overlapping consensus about what dignity means. So just as you wrote different things, but my guess is that you all wrote things that probably all of you would agree with. There probably wasn't any one of you, I'll find out later, but who wrote something that any one of us would be like, oh, that's weird, that's different, I wasn't expecting, Just as there's an overlapping consensus in the class, and I'm hypothesizing that there is, about what dignity really means, there is that same overlapping consensus in the court cases. So you can read a case from Colombia, and they may decide it differently than the Indian Supreme Court would decide a case. But what they're saying about human dignity is probably very much the same thing. So they're using different language, and I don't just mean, different language, but like they're articulating it in different ways. But what they're saying is probably fairly consistent. So but that's, we'll talk more about that. But that sort of is the question. And that's part of like the, going back to the reading list. And again, I don't expect you to sit down and like really work your way through all these hundreds of pages of cases. But if you even just skim them all, you'll see, like, for tomorrow, Francis Corley Mullen and the Canadian case, totally different context. One is about somebody who's in prison. The other is about fishing rights in Canada. Couldn't be more different, right? Sort of what they're saying is not that dissimilar. So we'll talk more about that. So let's take a tea break. And we can come back in 10 minutes. And then we'll continue with the cases. And while we're getting up for our tea break, let me just say, but for one reason or another, they're talking about what they think about human dignity as a legal concept, right? As relevant to law. And the question, and some of you have sort of asked this question, but I want to just sort of put it real specifically, real clearly, sorry. It's a complicated question about the relationship between dignity and rights, or dignity and law more generally, right? Because if it's inherent, then what does law have to do with it, right? If you're born with dignity, born with equal dignity, then why are we even talking about it as a legal concept? And the reason we are talking about it as a legal concept is that drafters of conventions and drafters of constitutions and judges think that it's important, think that in order to do their job, they have to think about human dignity in some way. And what those opinions are doing is telling us how they think about human dignity. And that's actually why I think there's such a remarkable overlapping consensus, is because not that there's agreement across the world that all constitutions should be interpreted in a certain way or all rights should be interpreted in a certain way. But if the task that you're engaging in is to try to figure out how the law should protect human dignity, that's where you get consensus, because across the world, people are pretty similar in what they need to have dignified lives. Not 100% similar, not identical, but people need food and nutrition to live a dignified life. They need housing and healthcare to live a dignified life. Maybe they need education to live a dignified life. Maybe they need to be not treated with, to be not humiliated, to live a dignified life. All of these things are part of dignity jurisprudence. And again, the reason that despite the enormous range and diversity of dignity cases, what they say about their constitutional interpretation may be very different, but what they're saying about human dignity is fairly similar. So trying to make sense of this vast jurisprudence, geographically vast, topically vast, coming from every different legal tradition, civil law, common law, religious law, secular law, however you think about law and the different, varieties of law, there's dignity cases there. And so to try to just organize it, because you can't talk about 1,000 different cases, you have to sort of organize it in some way. And I have various different ways of trying to organize the cases, but this is the one that we can use. I think that the dignity cases, by and large, fall into one of three baskets of rights. The first basket, if you will, is the right to be treated with dignity. And this is in no particular order. So I shouldn't say the first, but one of them is about the right. There are cases about the right to be treated with dignity. These are particularly, you see a lot of cases about the criminal law in that basket, right? Cases where people tend, where abuse is most likely and humiliation is most likely to happen in the context of the criminal law. So there are cases where courts will say, no, government, you cannot treat a person that way because that person has a right to be treated with dignity, right? Discrimination cases might be another example of that. So other ways in which people are treated with indignity will come into that basket. Secondly, cases about the right to live with dignity. And this is very much the way you think about it. If you've already all taken constitutional law, right? Yeah, okay. So if you think about it in sort of the Indian Article 21 context and what is necessary for a person to live with dignity, you see very, very similar cases in other parts of the world about the same thing. And these tend to be sort of socioeconomic cases, right? Social cases that arise under social and economic and cultural rights, those kinds of cases. And then there's cases about the right to the full development of a personality. And I mentioned that phrase previously, but you have a lot of cases. Another way that you can think about that third basket is cases about identity or individuality or individuation. Cases where a person is saying, I know the societal norm is X, but I want to do Y. And the court says, well, as a matter of human dignity, the government should allow you to do Y or be Y or whatever. So, for example, in the 2010s, in the 2000s and 2010s, there were, and I know there were cases here. When was NAS Foundation?
2009.
19?
2009.
2009. Okay, so right in there. There were cases like that all around the world. Came up in Latin America, came up in South Africa, came up in the United States, came up in Canada, came up in parts of Europe, dealing with gender, same-sex relations, gender identity, that whole sort of family of things. And I think these cases are fascinating because almost all of them came out the same way, which was with recognizing these new rights. And almost all of them could have been decided on simple equality grounds because they were basically cases about discrimination. They get this, they get to marry, I don't. They get, this right, I don't, blah, blah, blah. Or due process or liberty or some other specific provision in the Constitution. And I'm generalizing, but what so many of these courts did was choose to treat those issues as matters of human dignity. And so you see, so that's just an example of like that third basket of rights. It's really not just about, it's about who you are and how you become who you are as a person, right? And what's so interesting about these cases, I think also, is that as in the cases about sexual and gender identity and rights, so often courts choose to write their opinions around the theme of human dignity, even when they don't need to. So again, cases that could be decided on more explicit grounds, where there's an explicit right in the Constitution, a non-discrimination right, which is in every Constitution, and or whatever, they could have just sort of taken the easy way out and just sort of relied on that provision that's more specific, more generally applicable, where there's a sort of usually more elaborate body of case law. And sometimes they do, but they also, in the cases that are sort of interest here, they also say, but by the way, this is a matter of human dignity, and that's why it's so important. And that's what's interesting about these cases. So whether they're vindicating a specific right in the way that you were asking the question, sort of in that, like, when are they doing it very narrowly about your right to walk into court? Sometimes yes, but even when no, the courts are saying, hold on, before you get to the holding, before you get to the conclusion of this case, I want to say some pages about human dignity, right? And they just sort of go off over there and start talking about dignity. And those are the cases that I'm interested in, because those are the cases where we learn what courts think about human dignity, where they're developing that vocabulary. And they're not, I mean, this is obvious and, you know, probably goes without saying, but I'm just going to make the point explicit. We're not reading philosophy here. We're not reading about what is the nature of man. We're reading cases, courts, judges are very busy people. They want to decide cases as efficiently as possible. They want to decide cases in ways that are, even when they're the highest court in the country and they're not worried about being overruled, but they want to decide cases in ways that people will accept the case, right? Particularly in these cases where they're kind of going out on a limb, like, you know, in any of these issues. And yet they choose to stop and talk about human dignity and the relevance of dignity to rights and the relevance of dignity to law. So that's why these cases sort of are of interest. As I say, there's a lot of different ways you can organize this. I just find this kind of useful. But again, as we go through the week, I'd be interested to hear your thoughts on if you like, if it makes better sense to organize these in different ways. Yes.
So right now you talked about cases where dignity is, rather than being invoked as a right, value that the judges rely upon to maybe justify why they come to a decision, right? Does that in any way undermine the value of then invoking dignity as a right? Or does that like dilute the, from the point of view of law, you go out in a limb, as you said, you're going against what has been established for like years and years. So is dignity the right way to then go about it? Because as we talked about it, dignity can have very different meanings for the court and the state.
I think in the conference there was this idea of dignity inflation.
Yeah. That's
Yeah. He said, dignity enthusiasm is great, but dignity inflation, like where everything, you know, you increase the cost because everybody's talking about it so much. We should be cautious.
Mentioning that Dworkin also talks about it as having been
flabby.
flabby from overuse. I don't know how you can go flabby from overuse. I think it's exactly.
Yeah, I've tried not to. So I think, so a couple of things. In my own work and sort of what I'm bringing to you, I've spent a lot of time trying to categorize them in terms of this, like what they're talking about. I haven't spent as much time looking at sort of the question that you asked and the question that you are sort of positing, which is, and one could do that, I just haven't. Here are the cases where dignity is an enforceable right. Here are the cases where it's a value. Here are the cases where it's doing something else. I think that's a great research project. And even without engaging in a 2-year research project about that or a PhD about that, even just by the end of this week or by partway through this week, I'd be interested to know your thoughts about that. Part of the reason that I haven't done that is that I find the courts aren't always clear on it. And sometimes it's a right, or sometimes it's a value, or sometimes it's sort of both. A lot of times it's like an interpretive, an interpretive guide. Like you'll see in the equality case from Canada, dignity is not mentioned in the Canadian Charter of Rights and Freedoms. The case of discrimination, affirmative action, and equality. But the court says, in order to understand Article 15 or Section 15, our equality provision, we should think about it in terms of dignity. And there's a lot of jurisprudence like that. So I don't always know exactly what the court is doing with dignity. What's really interesting to me then is just not so much that, but how they're talking about it. What do we learn about what should dignity be doing in law? Why is it relevant to law? Why are all these courts talking about it suddenly? Regardless of whether they're doing it as a vindicable right. But again, I think that's a great, I mean, both of your questions together, I think that's a great sort of area of inquiry. And as you read cases, pay attention if it's of interest to you. Is this a right? Is this, and even, you know, in some, so you can just, she's just going to override me if what I'm about to say is she's just going to be like, no, that's just wrong. But it seems to me that in a place like India, where there is quite an abundant jurisprudence of dignity, to do what you're talking about, like in a global way, it is at least a PhD, if not 2 PhDs. But to do it on a country by country basis, I think is doable. And so one thing one could think about doing is looking at what is the place of it in Indian law. And what does it mean to say, I mean, clearly going back to the Constitution, the preamble, it's a value, and going back to other provisions in the Constitution about untouchability or other things, it's a value. And then is it a right to dignity or a right to live with dignity? Does that make it a vindicable right, et cetera? You know, it would be worth exploring in the context of just one country's jurisprudence, what the court is doing with it, how much is it an actual right? And your question is, if you treat it so much like a value, are you undermining its utility as a right? So I think all those are great questions for people to explore. Okay, let me tell you a little bit about what I mean about, I think okay, I'm doing this sort of in a different order, but anyway. So right to full development of the personality. What was the first one? Right to be treated with dignity. So these are the cases, these are the kinds of cases that you see in sort of the basket that I'm calling the right to be treated with dignity. And this has to do with the idea that to be a human being is to have a certain status. To have dignity, to be born with dignity, is to be important in some way, to have worth. And everybody has equal worth, right? I mean, just it's important to sort of go back to that basic concept of what we mean by everybody is born equal in dignity and rights and has inherent dignity. And there seems to be the suggestion that there is like some substantive component to being a person or to having dignity. And that if you treat somebody with respect, you look at them in the eye when they're a defendant in court, you allow them to stand or to sit or to do whatever they want and to dress a certain way, whatever, like all these different things, that there is a way of treating somebody with dignity, with equal respect, with the kind of respect that you would want and with equal respect. And there is a floor below which you should not go.
Clarifying, you said individuals and government. So this whole distinction that we make between horizontal and vertical. You're saying it is in both cases, right? Not necessarily only that state needs to treat you with.
Yeah.
Like most of the 3 cases, I mean, in a way, all of them are state dependent. Whereas there you've said it's individuals and governments. So I thought.
I think I don't want to say that there's a blanket rule that it's always vertical and horizontal. But I will say that I think the dignity cases, more than other kinds of constitutional cases, blur that boundary. And whether it's an individual, say, committing a crime of, let's say, sexual violence, or the state failing to punish and prosecute somebody for doing that, the court is still looking at that as a dignity violation. So there are, the same is true actually with positive and negative rights. I'll just say right now, where that distinction exists in some way and is blurred more in the context of dignity law than elsewhere. That's an aside, but just,
For example, the examples that Justice Muralidhar was giving, right? The entire Prevention of Atrocity Act is a list of things that you should not do to the other. The whole way in which Dalits and
right.
the statute itself reads like a charter of dignity, but it's
Of horizontal and,
it's criminal law which state is enforcing to make sure that one person does not treat the other person that way. So point that you were making, that really you can't classify it as horizontal or vertical, because while the state is implicated, it is the action of the individual that you're trying to.
right. I mean, what I would just say is that where we're operating here is at a very high level of generality. And so I don't want to make a specific statement that globally the rule is always this. There are cases where the court is clearly requiring government action. There are cases where the court is clearly not requiring government action. There's a lot of, in this employment-based cases, right, where somebody will sue an employer for violations of dignity, and the court, in a given instance, in a given jurisdiction under the right law, will accept that as a dignity violation, accept it as a case. So there are variations within that. I wanted to sort of just put that in the slide because the question is an important one, even if it's hard to sort of say categorically what the answer is, because every jurisdiction is situation which, yeah.
According to which dignity is more important, social dignity or economic dignity? Second question is, how many cases on economic dignity have you come across so far? Because there are filthy rich people and there are people in contrast where they are not even able to get any ambulance to carry their loved one's dead body.
So any question that you're going to ask me that's like how many, I'm not going to be able to answer. You know, I can say there are some or a lot or a few or something, but I don't have an answer to that. Can I just hold on to that question for just a moment? I just want to sort of finish with this, and then focus on the cases about the right to live with dignity, which is really where your question comes in. These are the social and economic cases. In all of this, you have to keep in mind that we're talking about judicial decisions. We're not talking about philosophy on the one hand, so just like very abstract, but we're also not talking about a political science white paper or an economics thesis or something like that, right? So these are cases where the court is sort of going somewhere into philosophical questions about what human beings need. I mean, this is Francis Corley Mullen explicitly, like, what does a person need, right? More than animal existence. But not too far away from the fact that they have to write an opinion that has to get implemented, it has to be accepted, etc. So I think, frankly, on the real hard questions of economic justice, you'll get opinions that hint at an awareness of economic injustice, but it's the rare court that has the ability to say, you know, the kind of what you just sort of gave, you know, that can't be, and we need a different economic order to ensure that there's less inequality. There are cases, I don't think it's in the reading. There are cases, for instance, from Germany I'm trying to think of another example also, is escaping my mind. There's a case from Germany where the legislature was setting out what the pension amount should be. And in order to balance their budget, they set it here. And people challenged it and said, we can't live on this. And the court, and this is, as you can imagine, this is one of these things where it went back and forth. There's like 4 different cases from the Constitutional Court going back and forth. But the upshot of it is that the court was very emphatic in saying, it's not our job to decide what the amount, what the number is, how many euros a person needs to live on per month. But it is our job to say that a person needs to live with dignity. So legislature, you figure it out. But we're going to tell you that the constitutional line is living with dignity. So when you figure it out and you get challenged and you come back into my court, the court's going to say, can a person live with dignity on this amount? Now you can, I mean, that's so complicated in so many ways, right? Like, how is the court going to figure out what it means to live with dignity? But it's accepted that challenge. As a matter of separation of powers, it can't go too far. It can't say the amount is 500 euros a month, but it can say it's up to you to justify that what you're doing, legislature, allows everybody to live with dignity. That case was then extended to asylum seekers. People who, I mean, I know you know what asylum seekers are, but I'm just saying in the context of this, people who come to Germany and while they're in that interim period where they're seeking asylum, but they haven't been granted asylum yet, they have to be able to live with dignity. They're not German citizens. They're not even necessarily there legally in the sense that their legal right to be there hasn't been adjudged, but they are on German soil and the court says they should live with dignity. And maybe it's not exactly the same thing as German citizens or whatever, like we'll leave that to the legislature, but we'll at least look at that. So there are cases, and I think that's a particularly important one because it shows, first of all, the German constitutional system's commitment to living with dignity. And secondly, it shows that that separation of powers tension can be negotiated. And the court found a way to say, this is your job, this is our job. The issue, the way you phrased it, is I can't think right off the top of my head now of cases about inequality the way you were describing it. But there are cases about poverty. But even those, as you can imagine, I mean, it's easy enough for a judge to say, living like that is not living with dignity. And quite another thing for a court to write an opinion that's going to have the effect of being enforced that that person is not. So just to tell you, you all know the case, the Olga Tellis case? That was the first case I ever read about dignity. And it was the case that sent me down this path for the last many, many years. Because I could see the court struggling with it. And it's not necessarily a great case in terms of, you know, it didn't result in ending homelessness and right, but it was trying to deal with that, trying to, you know, I thought I saw someone's hand go up. Okay, so these are cases about what it means to live with dignity. You will see a lot about this in the Inter-American Court's recent case about climate change, because one of the things that the court does there is the Inter-American Court system has a incredibly elaborate jurisprudence of dignity. So they weren't sort of going on, you know, sort of new, it wasn't new ground for them, but they do spend a while explaining the human dignity impacts of climate change and the way storms and fires and floods and all this other stuff that we're seeing affects people's rights to all of this, including the right of belonging, which is sort of the right to have a community. And actually the court talks about the right of belonging as well as these other rights. And in that case, by the way, they create a right to a healthy climate, not just a right to a healthy environment, but a right to a healthy climate in that case. So that's the right to live with dignity. And then there's the right to the full development of the personality, which, as I said before, these are cases that have to do with sort of the individual. Freedom of expression, the sort of purely mental processes, these kinds of rights. And then a lot of cases, the Putaswamy case might be in this category, cases about privacy and information. And obviously, I mean, you all have a major decision on that fairly recently. But we're obviously going to see more and more of those kinds of cases. Technology challenges the boundaries of the individual. What's yours to hold on to, what's yours to keep and to control. These are often cases about not just identity, but also agency, about the ability to control your life, the ability to make decisions for yourself. So cases about choice of employment, for instance, cases about choice of marriage, not just in the same-sex marriage context, but in other contexts as well, where it's a part of how you see yourself and how you see your life, and what they call in the inter-American court system, the right to have agency over your life project. Abortion decisions, a recent one from India, a recent one from Mexico, very similar opinions actually, that talk about sort of the impact of abortion restrictions on these kinds of interests. Okay, yes.
Could you maybe elaborate, since we're talking about full development of the personality and gender is obviously a big role, plays a big role. There's been a bunch of cases, I think, in Russia as well as the US, both ends, about how anti-LGBTQ curriculum has been dealt with in schools. And one thing that I found interesting, and correct me if I'm wrong, is that in Russia, they invoke the dignity of the parents to be able to decide what their children are exposed to. And that's a very different kind of dignity that, at least I've never come across this conception of it. And I just don't see how we can reconcile these very different understandings of dignity, and how do we then balance them if there is a balancing to be done when, there's obviously the child's right to development, and then there's also access to information, which a child might be denied in their books.
I think maybe the question of what is not dignity.
Yeah, that.
Like that's the
Right.
Russian case, right? Where they prevented any information that was to be, put in the public domain about allowing adolescents to.
That they called it propaganda.
Yeah, but I think it was the family right of dignity.
This
that
is
they
the
were talking
bio
about.
case, right?
Yeah, the bio case.
So when I say I think there's this great overlapping consensus, I do not mean that the courts are all ruling the same way. But I'm not sure that even in that case, it's different conceptions of dignity. I think it's more different rules about whose dignity claim controls, and how and what countervailing rights there are or whatever. So those are like specific to, but even in that case, in those kinds of cases, the parents are essentially making their claims also. I mean, one may not agree that it's their dignity, right? But it's not a terribly different conception of dignity. It's just applied in a way that we may not think is we may not agree with. Children's dignity, I think, is really interesting and really complex. All members of the human family are born with dignity, so you get dignity from the moment of birth. But clearly, people have different dignity rights as they get older. I think there are dignity rights that attach from the moment of birth. You have a right to live with dignity. You have a right from the moment of birth to clean water and adequate food and a healthy environment. You also have rights to be treated with dignity, to not be abused. Like those rights attach instantly from the moment of birth. Other rights, the right to vote, maybe that takes a few years to develop, right? The Convention on the Rights of the Child is very clear that children they don't specify the age, but children under 18 have rights of participation, the right to be heard, the right to speak, the right to full development of the personality. So that's in those cases, that's a complicating feature of the case because you're dealing with children's rights also, as opposed to the rights of two adults to information, right? The competing rights of two adults.
Are we saying there is no such thing as a wrong claim to dignity?
No, we're not saying that. So what would be an example of a wrong claim to dignity, or a claim to dignity where the consensus might be, nah, that's not a good use of this? Can you think of any example where you would say that's really not?
Very often in India, for example, I think this came up in the conference also. Family's question, I think, where there's like a runaway couple, and the family suddenly says, I mean, they use the word dignity, dignity with honor, in the Indian sense, where they say, oh, the family is given the honor, is but then I don't know if it's a great dignity versus an individual, but that's how I.
So I want to talk about that question. We had a big debate about this last night, and it came up at the conference. The question of community dignity and group dignity, I do want to talk about, but
It's not really a community idea of dignity. This idea of honor. Necessarily a community. I mean, I would not want to call it a community right at all. I don't think that's the community right we're talking about. More group rights that we're talking about are the ones that you put up, right? The right to water, food, a clean environment, are socioeconomic rights which have to be enjoyed not individually, but everyone has that as a community. That's the idea of community dignity that I can envisage. Honor, obviously coming from very specific cultural ideas, and I'm not so sure that it gets recognized as a community right.
It's about like terms of rights which are given to specific religious groups, even in the constitution with respect to right to religion, which is vested in different community as a whole. So wouldn't that be a kind of community right?
Which is where I'm wondering, how does one deal with this business of honor? Because religious freedoms, conferring religious freedoms, particularly on minorities, is a very essential part of non-discrimination law, very much part of dignitarian law, that you have to, recognize and respect cultures that you disagree with. All of that is okay. But when it moves to at least in the entire South Asian context, we talk about honor killing. That's the context that we are looking at honor. It's not just about respecting other people's ideas of difference. The non-respect of the other's idea of difference, which is where the honor business comes in, where you believe that you can do things in the name of honor, which should otherwise not be sanctioned by law or society or anything, but you're claiming some right that your honor has been violated. So I would, that's the idea of not being a dignity right.
To play devil's advocate, though, we acknowledge that law is not the only system and not the only structure in place in our lives. So wouldn't any cultural group have the right to organization and to penalize members who go against that organization? And that would mean, of course, killing is objective.
So that's the question. Right? I mean, we have specific contexts. Can dignity rights be claimed in the context of violence towards another. Let's make it very narrow. A very specific question that can we say that a raw claim of dignity would be where you are committing injury, physical, mental, moral injury on another, and that can't be done in the name of dignity. I mean, that's how I'm wondering, how does one formulate anything which should not be claimed as a dignity right?
So I mean, in a way, it's much simpler than that, because I think that raises just all kinds of like complicated cultural questions that I'm certainly not in a position to opine about. But in a way, the question is actually the way you're phrasing it. It seems to me it can be said even more simply. Can any one person or group or whatever claim a dignity right to violate the dignity of another? Right. And then you have a complicating factor to that question, which is, what about instances where the person whose dignity would be violated, consents? So let's hold on to these as sort of some of the very difficult questions of dignity law. And sort of see how our thinking about dignity evolves, about dignity rights evolves. Do you want to say something?
No, I was just going back to that question about like, can an individual claim a right of dignity to violate someone else's dignity? I don't know. I feel like that sets it's a tricky question, because that's also something that, pro-life people kind of argue, that saying that, like fetus also have a right to dignity. So I don't know, like it's there's no clear right or wrong answer to it, because I feel like the answer will change according to the context. So
right. And that's okay. I mean, we don't have to answer all these questions. I think one of the things that dignity law does best, if you will, is help us think through these questions so that we can get more sophisticated than, oh no, that's terrible, or yes, I believe in this. But to sort of say, let's look at it through a dignity lens and see if we're thinking about this in terms of these rights, in terms of these human values, how would we resolve this question? And we may, we may have general agreement on what human dignity means and disagreement on how we resolve it in a given case. And that's okay. The point isn't to compel an answer. The point is to think through rigorously what's at stake and what are the non-negotiables, like what has to be respected no matter what, and what can be compromised with.
Just a question that if you could answer this while discussing that, is it even desirable to have a minimum floor of dignity? Just like Professor Vasati was telling, that okay, like dignity would be not like something would not be dignity if it involves injury to a human body. Like at that moment, it would stop to be a claim to dignity. So, like, is it even desirable to have a minimum floor? And if it is not desirable to have a minimum floor, then we are just leaving the framework of dignity to be susceptible to politics of each court. In the end, in the case of Russian case, the court used dignity framework to just to enforce the politics of the Russian society, or whatever the discourse was holding.
Mm-hmm.
So is it even desirable to have a minimum floor? Because in the end, law is always in the end results into the articulation of the politics of the court at some level.
Yeah, I agree with that. I feel like the way you're phrasing your question, is it even desirable to have a floor? You're sort of suggesting that it isn't?
No, so I want a minimum floor. I
Yeah.
want that some universal value
Right.
should be acceptable. But is it right in the end? ICCPR or all of these are not binding, because China always says that US is not the democracy of US is not the real democracy. Our democracy. Yeah. So that is laughable.
I'll try not to say anything about that right now, but
That is laughable. But in the end,
Unfortunately.
they are saying this
Right.
only, that like that that culturally specific things should be respected. In the end, there might not be any universal values which might be accepted.
Okay, so there's an easy answer to that and then an unanswerable part of that. So I'll give you the easy answer to it. Under international law, there's something called jus cogens, which is basically a set of rights that are non-derogable. In other words, a set of rights where the international community has said, under no circumstances is this ever permissible. Slavery, human trafficking, genocide, things like that. Those are, in my view, and jus cogens doesn't say this explicitly, but the reason those are absolutely never permissible is because they are the most profound violations of human dignity, right? That's what makes them so horrible. So the easy answer to your question, or the part of your question that's easily answerable, is the international community, and notwithstanding countries that violate the law, right? I mean, there are lawbreakers, but the one thing that there is the most consensus on is that these are things that are never, ever permissible. So that's the floor. And I do think that they relate to human dignity, right? They are this. So, and as we'll see maybe in some of the cases, there are cases, and these torture. Courts, and again, sort of keeping in mind the distinction I made between international law and constitutional law where there's jurisprudence, courts will invariably say that that torture is an absolute prohibition, that you can never make a finding, this was torture, and then ask the government, so what was your justification? The court will always say, you might have had a good reason. Maybe you needed that information. Maybe go ahead and pursue that good reason without engaging in dignity violation of torture, right? So at the international and at the domestic level, there are certain things that simply are floors because they are the most abject violations of dignity. Beyond that, then it's really hard to, and those are things that are not sort of culturally, you don't get a cultural exception. Oh, but in my culture, in my religion, we torture people. That's not something you can say. So there are limits to that cultural specificity argument, not to say relativism, but that, this is how we do it. And that's, again, the value of having this worked out at the constitutional national level rather than at the supranational level, because it allows each country court to say, we have a group that engages in this kind of behavior, but it's not okay. And this is, again, what, it came up in the justice's comments that even aside from torture in the sort of most extreme ways in which we think of it, there are practices that have been done for millennia that have always been accepted, and courts are using dignity to put an end to those. So I think I might have mentioned it, the very first sort of invocation of dignity as a foundational value in the European Court of Human Rights was in 1995 in a case involving marital rape, right? So a guy gets accused of marital rape, gets prosecuted, goes to jail, and he challenges it in the European court. And he says, why are you prosecuting me for this thing that has always been permissible? And he's absolutely right. It has always been permissible. And the European Court of Human Rights says, you're absolutely right. And yet, now, we think about things in terms of dignity, that behavior may have been acceptable, but it violates another human being's dignity and it's impermissible. And the UK has a right, I think it was the UK, has a right to punish you for it, so you lose. Even though he was right on the facts and on the law, right? So cultural specificity, historical specificity, whatever, dignity limits that. And courts are using that. And that's why, just to go back to what I had said at the very beginning of class about the Universal Declaration of Human Rights, there are suggestions in that preambular language that they are thinking about dignity as this pivot. It's always been done this way. Your community, your religion, your beliefs, whatever, have always permitted this. Now that we're in this mode of thinking about human dignity as the foundational value of our time, that's no longer acceptable. So it's a tool the courts use to pivot away. This is the same-sex marriage cases also, right? Clearly, they had no right under existing law to same-sex marriage, and the court says, but those existing laws violated dignity, so you do have that right. These are tough cases for courts because by definition, they're going against community norms and community expectations, right? So courts in these cases are by definition going out on a limb and saying, this is no longer acceptable, even when lots of people are claiming, but we've always done it this way. So I think the line about like what you can do in your culture and how much you clearly you have space for that, but dignity imposes a limit to the kinds of things that you can justify. So if the justification is, or if the thing is, honor killing, okay, agreed. It's been done. It's widely practiced. Agreed also, it's not consistent with a system based on human dignity. And that's the floor. That's the limit to it. I don't know if that. What I want to that was really tough and complex. We're getting to something that's much simpler now. And I think very intuitive if you think about it. But if you think about bills of rights and constitutions and covenants, they're just lists of rights. And they're always unconnected to each other. It's just like you have a right to this, you have a right to that, you have a right to that. And courts have typically interpreted rights in constitutions in this kind of siloed way, if you will, or just like, we're just looking at this right. Dignity, when the international covenants both say that all the rights in this document derive from the inherent dignity of the human person, what they're really saying is that dignity is like this source, and all the rights come from that. And it's an invitation to think about rights as being indivisible and interconnected and interrelated. And so again, in this climate change case, for instance, it's a list of all the different rights that are affected by climate change, understanding that they impact each other, right? If you have a flood that comes through, you can't have crops anymore, but that also means you don't have employment anymore. And that also means it's hard to go to school because you're hungry, and that also, et cetera, et cetera. So that you can talk about the individual specific dignity rights, but also understand that they are interconnected and interdependent. And human rights law, since for the last 30 years, has been understood to be interdependent and indivisible. But I think that what dignity sort of makes that very clear, that if they're all coming from this one source of the inherent dignity of the human person, all rights are connected from that. Okay. I'm going to make this available to you, but so we're not going to go through it, but this is actually something that one of my classes did, where we were just naming all the different kinds of, it was at the end of the semester, and we've been reading dignity cases all, for months. And the students were sort of saying, what are all the sort of ways in which we've seen dignity. And then I just put it into this like wheel. But you can see a lot of what we've already talked about. And this, again, is not in any particular order because it's all interdependent. But the inherent worth of human life, equality, which of course we'll talk about more, anti-objectification and humiliation, those kinds of ideas, agency or control over your life, living one's truth. So this is the language of my students, but free will, conscience, the idea of being your own person, your identity, the full development of the personality, your privacy rights, of course, as you know, are part of dignity. These are dignity rights that are not so much internal, but that external side, that relational side, right? So you get your identity through other people, the concept of Ubuntu, if you've seen it in certain South African cases, and connected with that, the dignity of belonging to a community. Participation, democratic rights, that was the last hour of today, but that's okay, we'll come to it tomorrow. Humiliation, we've talked about bodily integrity, the right to bodily integrity, protection from vulnerability, and the right to live with dignity, and the right to be treated as a person, as if that sort of means something. Okay, and then I'll close with this, and those of you who were at the conference heard this, but this is my theory of dignity rights. My theory is that if aliens came to land on Earth and didn't know what human beings are and saw people milling about and thought, I wonder what those things are that are running about, if they decided to read a bunch of dignity cases, like the only thing these aliens did was they had the internet, they went to my website, they looked at this database of cases and they just started reading all these cases, they would have a pretty good idea of what human beings are all about, because they would learn from these cases that individuals, that human beings want to be treated with dignity by other people, that they want to live a certain way with dignity, and they have certain, sorry, let me go back to this, they have certain biological and other kinds of needs to be filled. And they have these things called personalities that they want to protect and treat well and develop fully. So that's my theory, is that you can learn a lot about humanity and what it means to be human anywhere in the world and under any different circumstances from reading these cases, because that's ultimately what the courts are talking about. So, any other questions? Any other thoughts? So what we'll do tomorrow is we'll start with the participation rights. And what I'd like to ask you to think about overnight is, what's the connection between all of this? What's the connection between all of this and democracy? So we've been talking about this one big concept of dignity today. Tomorrow we're going to start by connecting it with this other big concept of democracy. Courts have said that there is a relationship, but the question is, what is that? So that's where we'll start tomorrow. Okay? You have my email. I know some of you already sent me your email, so thank you for that. If you haven't done it already, please do so. And if you'd like to meet with me or talk about these issues or anything, please feel free to reach out. Okay? Thank you, everybody.